Good evening, everyone. You're all very welcome. My name is Eve Patton. I'm director of the Trinity Long Room Hub, which is this building. And this, for those of you who haven't been with us before, is our research institute for the arts and humanities. And the hub runs a regular Behind the Headlines series. And this is to explore issues that are current in the news and ideally to bring to them some insights from our scholars and researchers and experts in the arts and humanities, whether it's from history or from language or from literature or from ethics, philosophy, law, or simply from human experience. Behind the Headlines is sponsored by the Pollard Foundation, so my thanks to them and to you for joining us this evening for this discussion of the meaning of home. And of course, that is in advance of the coming referendum, which is on our minds at the moment. As you know, on the 8th of March, voters will be asked if they want to amend the Constitution, first of all, to provide for a wider concept of family, and then, of course, to think about removing that problematic reference to women in the home. But also, as you will know, if they wish to insert a new article, and this has to do with the provision of care. Now, we realise that these are, in language terms, in legal terms, in all respects, quite complicated articles, quite complicated amendments. So I hope you will forgive us. We have put the textual suggestions on a handout for you, which we don't normally do, but we thought it might be useful for some of you if you want to refer, as the speakers are talking, to what is actually being proposed in terms of these changes. Again, as you all know, Ireland's constitution has been amended in the past, and I think Ireland is rightly proud of the fact that it can evolve and change in this regard. But these decisions are never straightforward, and the decision in March is complicated by conflicting ideas of gender roles, by conflicting ideas of what domestic life represents, of family, of marriage, of what relationships consist of care and carers, and above all, perhaps, of the concept of what home means. Now that we've moved so very far from 1937 into an era when, as you know, the idea of home has become, for many people, an increasingly fragile expectation. So to help us through these questions and to discuss the changes that have been proposed to the Constitution, I'm really pleased to welcome four speakers who are all qualified to talk on this subject from different angles. And I'm going to introduce them only very briefly so that we have plenty of time this evening, in the order that you'll hear them speaking. So first of all, we'll be hearing from Professor Lindsey Earner-Byrne, immediately on my right. And Lindsey is the Professor of Contemporary Irish History in Trinity School of History and Humanities. She joined us last year. She is widely published, again, as many of you will know, in the areas of gender roles, domestic life, and child welfare in relation to modern Irish history. And so she'll be able to trace for us some of the historical backdrop to the current proposals. Secondly, we're going to hear from Dr. Claire O'Connell. And Claire joins us as a legal expert specialising in questions of Irish law and the recognition of parentage and of children's rights in the context of assisted human reproduction. Claire is a board member of LGBT Ireland and serves on the LGBT Plus Parenting Alliance, and I think is very well positioned to speak to the complex intersections of constitutional law and shifting definitions of the family. Third, we will hear from my colleague, Professor Rachael Walsh, who joins us from Trinity School of Law. Rachael is a constitutional law expert, but she's also a property lawyer. I'm not sure if that's good or bad, but she is the author of many works, including Property Rights and Social Justice from 2021, and is co-author of Kelly, the Irish Constitution from 2018. So again, extremely well qualified to talk this evening, particularly, I think, on how existing constitutional conceptions of home have interacted with protections for family and women in various court decisions in the past, and what ramifications these might have for our decisions in the referendum. And finally, we'll be hearing from Senator Tom Clonan. And Tom, again, I think many of you will know, serves on the Trinity College Shannon panel. He will address the proposed constitutional amendment on care this evening. And this is as it relates to the responsibility of family. And you'll see in the handout the article, the proposed 42B that he'll be speaking to. I think many of you will be aware from the media of just how frequently and how effectively Tom has contributed to discussions, including those that have taken place in the Shannon, on the 39th Amendment of the Constitution, the Family Bill in 2023, and how warmly and emotionally he has spoken about his own lived experience as a carer and about disabled citizens' access to supports in the community or outside the home. So these are our 4 speakers. They each have a very limited 10 minutes to speak to this topic. And then we're going to open to you, to the audience, for your questions and comments. So please keep these in your mind as you listen to our speakers. I'll not be coming in again between them. We'll simply listen to them in that order. And I'll hand over at this point with a welcome to Lindsey Earner-Byrne. Lindsey.
Has a stopwatch. I see some of my students in the audience and they'll know that if I didn't have a timer here for 10 minutes, there's no way I'd stick to it. So I'm going to press that on and start. Thank you very much for coming. I think it's wonderful in our democracy that people are so interested to be informed when they go to vote. And I think that's the most important thing that we're going to do this evening. Whatever way you vote, that you'll hopefully leave here this evening knowing maybe a little bit more about some aspect. I'm not qualified in the legal part of it, but I think I am in the historical context of the Constitution itself, the 1937 Constitution. And I think its importance historically is that it was part of a process of shaping citizenship in a relatively new state, and in particular engendering that citizenship. And this was something that had been happening gradually since the foundation of the state in 1922. I think also the vital context for thinking around the family and women's place in the Constitution and actually in the home and what was meant by that term is the anxiety mounting since the war regarding women's increasing public role in society. The victory over suffrage, which many people regretted in the political establishment of Ireland of the day, the violence during the Civil War in particular, where women had quite a prominent role, and the prominence in their role was actually inflated in much of the media. They were referred to as crazed women by members of the Catholic hierarchy. And I think we need to remember that was still very much in people's imaginative mind's eye when they were thinking about writing Ireland in a constitution. Also, another really important thing to keep in mind is the 1929 crash. It's vital in terms of reconfiguring contemporaries' understanding of unemployment. They were gradually moving away from the idea of the idle man, that kind of moralistic sense of those who didn't have work, gradually into the concept of unemployment being structural. And because it was so widespread after 1929, it really forced people to think about the economic model and the way in which they could possibly, I suppose, protect the majority of people. And they landed on the breadwinner model. The idea that if the man, the family man, is paid enough, what the Catholic Church referred to as a just family wage, then there would be no need for women to take men's jobs in the market. And I think it's really important because women were situated as problem workers, and you see that really starting in the 1920s and 1930s. They're undercutting men, which is ironic. They're blamed for the fact that they're paid badly, but there you go. And there's all sorts of voices in the public arena anxious about this worker and what she's doing to undermine the family, at the same time as being anxious about the female voter and what she might do with her newfound power. So I think that's really important to remember. And I'm struck by some of the debates at the moment about the current decisions we have facing us, how much of our contemporary anxieties are informing that as well, but also how our understandings right at this moment. Somebody was saying that the 1937 Constitution is value laden. Of course it is. That's the point. And now we have a chance to reflect on those values again. But in terms of the reaction to the Constitution from the women, which I've been most interested about, and they had a fairly visceral reaction to the articles that were being asked to consider in March. They'd been watching their newfound citizenship, this equality without any bars promised to them in 1916 being frittered away bit by bit, and had very good reason to be anxious. They, unlike many of their male counterparts, looked out at the growing fascist Europe and realised where that could lead if the state had too much power. This starts with incremental things like the 1924 statutory order, which limited the number of females working in the civil service, denying them permanent posts, denying them access to pensions, and insisting that they retire on marriage. This might sound like a small thing, but women's growth and education in the 19th century had resulted in almost a 200% increase of women in clerical jobs. So they were a really visible manifestation of women's changing role, and they were causing profound anxiety. So that was one easy way to sort of cut that path off. And how was it cut off? It was cut off on the grounds of protection of the family. And I think that to me is really important, what Sarah Appy calls the ruse of protection. Which is in fact actually another word for control. So they were anxious about this, they knew what it was, they called it out for what it was. Then 1925, the new Free State government moves to close down the option of having parliamentary divorces. This was an option open to very few people as it was, but it was a signal of where the state was going. And then the 1927's Juries Act. And I'm not even going to go into any of that because I've got experts on the panel, but I always say to my students, the thing that really upsets me most about that, and the women campaigners at the time were well aware of it, is less women's obligation or right to serve on juries, but rather all those women that came before the courts and were not judged by a jury of their peers until after 1975. And what, in terms of what that did to justice, we don't know, because we kept such bad records of the courts. So actually trying to figure out exactly the way that laid out, but there's no doubt that must have changed one of the most important arenas for democracy, which is the justice system. You removed women's voices in such a crucial way. And then the 1932 marriage bar. And this is a shopping list of which was all on these women's agenda when they came to the Constitution in 1937. The marriage bar is targeted at teachers because, of course, that's another area of massive growth for female employment. But what research has shown is that it gives license to every other employer to create a de facto marriage bar. I think we have a maternity bar now, but the marriage bar is what was instituted across the employment market. And women saw what that was actually doing to women on the ground. Somebody mentioned in the introduction there the lived experience of many women who were not working to further their careers but to survive. And then the Employment Act of 1936, very much a response to the growing male unemployment, and it gives any government an opportunity to control women's place in the workforce. Now, I'm aware I've got 3 minutes and 46 seconds, so I'm getting to Constitution. Okay, 1937 Constitution. This is a project in some senses of one man, De Valera, but this is a man who thinks he channels the spirit of a particular type of Ireland. He's waited a long time to have a chance to write that Ireland, to fix the wrongs of the 1922 Constitution, and to express the spirit of the country he thinks that he is kind of coming to rule. He's helped by various other male figures, but virtually no women at all. The women, when they see the draft Constitution, very few people are consulted before this is published, are horrified that the clear, unequivocal promise of equality in the 1916 Proclamation and the not too bad promise of equality in 1922 is gone. And they're worried particularly about Articles 16, 40, 41 and 45. I'm not going to talk about them, but I think it's important to say that they win some really important changes in Articles 16, 9, 16 and 45. They get, without distinction of sex, included in those. If you check the Constitution after this paper, you can check how fundamentally that changed those. But they failed, if you like, in Article 41. And I think, I was asked about this earlier, why? Because it was a harder sell. Because for a lot of people, the idea that the state might actually not force them out of the home due to economic necessity was not a terrible prospect. In fact, Louis Bennett, who represented the workers' union, said, okay, she objected to the wording in the Constitution, and she said, well, first of all, if you really do want to protect women in the family, why don't you specify that fathers actually have to use the salary they earn to feed the children that they bring into this world? Where are they? And the second thing she said is, why don't you actually just get rid of poverty and unemployment, and then you don't need to be promising anybody any protection about anything. So and her words really, this is, 1937, they're as relevant today, I think, in many sense. She was also concerned as a woman who was not married, and many of the women who campaigned against the Constitution were in same-sex relationships, clearly worried about the sort of families that were being protected. But that was something that was too difficult to take on in the time, because the notion of the family was a very particular notion. You mentioned in passing property, And it was really about a bourgeois idea of the family, a particular middle class vision, those who could stay at home in that domestic paradise that actually was denied most people. Louis Bennett said 90% of the women she represents work through necessity, not because they want to. McQuaid, who was to be the future Archbishop, but he was very much the Archbishop in waiting because Archbishop Byrne was unwell at the time, said to De Valera, the feminists are confused. And he said, but not to worry, the encyclicals will set them straight. And other commentators within the Catholic media referred to these women as unchristian liberals who were seeking to exclude religion from public life. But actually they were very careful not to critique religion at all. And they realised that they had to work within very strict parameters. Just to end, I'd like to remember their successes. I also think they would be really stunned to think that it took till 2024 for us to be asked to consider this notion of the family again. Maria Luddy says it's like the last big campaign before the 1970s. I don't think that's actually fair. I think a lot of work went down at a kind of lower level. But I do think that one of the things that they were trying to say and that their feminism after 1937 showed clearly was that this constitution doesn't have teeth in terms of people's lived experiences and is not going to materially change anything, but it can be used actually to restrict the opportunities that women have. And if you look at the changes that happened over the 20th century, the thing that changes most is the development of single-headed female households. And the thing that marks them out from all other families is their vulnerability to poverty. And they are not included in the definition of the family. And I'm going to stop.
Hello. That was excellent. I'm really worried about how bad mine will go. I was really concerned, as probably a lot of you are, to see the Irish Times article that about 53% of the kind of people who were canvassed don't seem to fully understand the implications of the referendum. And look, lads, I'm a bit worried that after 10 minutes of constitutional law with me, I'm not sure if that will go down or up. But anyway, so I'm delighted to be here today. I'm very grateful to be asked. I'll be focusing on the referendum relating to the family and the proposal to include the concept of durable relationships into Article 41 of the Constitution. So before I get into kind of a whistle-stop tour of the case law, I'd like to ground us a little bit in what constitutional change can mean. So the best way to start, perhaps, is to explain that Article 41 is the article which bases the family on marriage. And it has historically been held this way for over 80 years, and this was reaffirmed only a couple of weeks ago in the Supreme Court judgment of O'Mara and the Minister for Social Protection. But that is not to say that unmarried couples or individuals do not have other constitutional rights. I'm a little sorry for any headaches I might cause by this next part, but it is different under the Constitution to talk about a married couple and an unmarried couple. It's different to talk about an unmarried man and an unmarried father. It's a different thing to talk about an unmarried woman and an unmarried mother. All of these have different constitutional contexts which arise primarily when a piece of legislation is challenged on the basis of its constitutionality and have regard to one of these people, one of these groupings. So it's also important to note that there's an underlying presumption that a law passed by the Oireachtas is constitutional, and also that the courts do show due deference to the Oireachtas in regulating and legislating for matters that we deal with on a day-to-day basis. So while the Constitution itself is kind of a proclamation of high-level rights, principles and values, for us that are supremely important, it's the government of the day and the legislature who really take what the courts say and push it into law. And that's what impacts, I suppose, for the most part, our lives and the choices made by those in power. So it's also the case to say that the case law in these areas trace back to In Riem in 1946, to Nicolau in 1966, Murphy in 1982, Re J.H. in 1985, J.K. in 89, War in 96, Vivian in 2006, J. McD 2010, MR in 2014, Gorey in 2020, and now the O'Mara case in 2024. So I was a bit annoyed today that I didn't bring any prizes for anyone who might be able to repeat all those back to me at the end of this. But the point I'm trying to make with naming all of those is that I've named about 11 cases there of that 80 years that give us a bit of a grounding in this. So it really is difficult to say on a day-to-day basis what a particular law might mean or what might be constitutional or not. So there are a number, however, of summary constitutional points that we can kind of get from the case law to date. So the first is that the family under Article 1 is the one that's based on marriage. This family is a constitutional concept that is said to be the primary and fundamental unit group of society, a moral institution possessing inalienable and imprescriptible rights and antecedent and superior to all positive law. What does that all mean? It just means that it's placed on this very, very high pedestal in terms of when the rights of the marital family can be interfered with. The second is that the unmarried mother has a constitutional right to the natural care and custody of her child under Article 40.3, and it's a natural right, so it's not dependent on her being married. However, the splitting of motherhood and surrogacy between the genetic and the gestational elements is not something as clearly constitutionally understood. The third is that the unmarried father does not have any constitutional rights, but that does not mean that the legislature cannot give him statutory rights in legislation. There is also a constitutional right of the child to the society of the father, and this is taken into account in determining what legal status he has. So I should also note there's been a considerable judicial discussion about the spectrum that exists about unmarried fathers and perhaps the level of interest or involvement that they may have in their child's life. And this will often determine how much power that can be given to that person. And again, it kind of follows into this idea of committed or durable relationships. So the fourth is that the constitutional rights of children are the same regardless of the marital status of the parents. This was only said really very clearly in case law, but it's been reaffirmed after Article 42A, which is the just constitutional article dealing with the children, and most recently in a case called Re-JJ and then in O'Mara. So the fifth is that de facto families, which have been held to be this concept of, again, a committed relationship, somebody who, I suppose, with a partner or with their children, have committed themselves to each other over perhaps a period of years, or have what the European Court calls family life. So the fifth is that these de facto families, as they've been referred to by the courts, are not recognised by the Constitution. So this has arisen in the case law in the context of an unmarried father who lived with the child as a family for 6 years, and also in the concept of two women who were not married and who conceived their child through donor conception. However, I should note this was before marriage equality. So finally, it's important to note that even where the family based on marriage is given a special status in legislation, this is always going to be subject to the equality guarantee in Article 40 of the Constitution. So this article prescribes that all citizens shall, as human persons, be held equal before the law with due regard to differences of physical and moral capacity and of social function. So what does that mean? It has meant in the first instance that married families can't be treated less favourably than unmarried couples. And while unmarried couples can be treated less favourably than married couples, it cannot be done so in a manner that's arbitrary, that's capricious. For example, any difference of treatment, it has to be rational, it has to be proportionate. And so this was evidenced most clearly in the O'Mara judgment, which I've mentioned. This case arose in the context of a man who had been in a relationship with his life partner for almost 20 years, over which time they had 3 children. Very sadly, she died in 2021, and Mr. O'Mara was refused access to the widow's contributory pension, which was only available to spouses and surviving sole partners. So the court unanimously found that this was unconstitutional, having regard to the equality guarantee of Article 40, insofar as it excluded Mr. O'Mara and his children. However, the court split slightly in their opinion as to whether or not the family under Article 41 is still the one based on marriage. So the majority opinion, which was authored by the Chief Justice, Mr. Justice O'Donnell, found essentially that Article 41 only applies to married families, and while he criticised the approach of previous courts to unmarried persons, particularly parents, he found himself simply unable to depart from the precedent that existed for about 80 years. So Mr. Justice Wolfe and Mr. Justice Hogan dissented on the basis of kind of a textual analysis of the reading of the articles around it. So for example, Article 42 that comes right after it, it talks about parents and children, and it talks about their right to education. So Mr. Justice Wolfe, for example, is saying, well, come on now, if family is only that which is based on married families, we can't, for example, say that the right to education is only available to children of married couples. And similarly, in Article 41.2, the woman in the home, we can't say that she is only a married woman. However, again, they're in the minority judgments. So I suppose Mr. Justice Hogan essentially argued that while the family is founded on marriage, that doesn't necessarily mean that Article 41 is exclusive to the married family, but it's more of a jumping off point to focus on the tenets of marriage, that being committed relationships. Although I should say that he noted that all marriage relationships aren't necessarily very committed, but anyway. So what does all this mean in terms of the referendum? My own view is that there may actually not be that much practical change by virtue of this amendment in light of the precedent set out by O'Mara. So O'Mara is an incredibly important, helpful case, and had it not happened, I think this amendment would have meant a lot more. But by virtue of that judgment alone, the legislature should be reconsidering a considerable amount of laws that differentiates based on marriage or civil partnership to those who are cohabiting. So to vote yes would be to align with the Supreme Court's thinking and further push the legal and symbolic case for more inclusive legislation for committed relationships, notwithstanding the absence of marriage. A no vote would perhaps be seen to a future bench as a clear rebuttal actually of the Supreme Court's judgment, which was more inclusive. And it could perhaps solidify that the state can offer less protections to unmarried couples and perhaps even at a lower threshold than the court found in O'Mara. So I should note that for anyone who is considering voting no because they have a concern about married families being dropped from the hierarchy, Article 41.3.1 is the second half of the first referendum, if you like. And what it says, it continues to say, is that the state pledges itself to guard with special care the institution of marriage and to protect it against attack. So even, for example, if we do change Article 41 to include durable relationships, there is still a constitutional guarantee that the state can still favour married couples. Therefore, even if the referendum passes, the court and the legislature will still be entitled, basically, to favour married couples. And so if O'Mara hadn't happened, basically, this referendum wouldn't pack the punch that I think it intended to do. So thank you so much.
Thanks very much. I'm going to take the baton fairly directly from Claire and speak to you about the conception of home that we can see in Article 41.2 and how that connects to other ideas of home in the Constitution, and then speak a little bit more about the background to the wording that will be before everybody in March on changing Article 41.2, that is the protection for the place of the woman in the home, as it is colloquially put. Lindsey very helpfully set out a lot of the background to the Article 41 provisions. Significant to note, I think, that these provisions in relation to the family were new, very new, in 1937. The 1922 Constitution that had come before us contained no such provisions, if you like, laden with Catholic teaching in respect of the family and the home. So its introduction in 1937 was a new departure, and it was a new departure that sparked debate in the Dáil at the time, particularly around the provision in relation to the role of the woman in the home and whether in reality the provision included had any teeth at all. So there were some suggestions in the Dáil debates that in fact this provision was in substance a provision that could have been included in Article 45 of the Constitution, and that is a place in the Constitution where principles of social policy are located that are not in fact justiciable. That's to say, you can't raise those principles in court as a means of asserting rights. And the concern that was reflected in the Dáil debates in that respect has really been borne out in substance, insofar as the provisions in relation to the woman in the home have had very little impact on judicial decisions in the courts, and equally very limited obvious impact in policy making. So in the legal sphere, really one notable case over the whole history of the 1937 Constitution can be identified where a meaningful attempt was made, if you like, to use the provision in relation to the women in the home as a tool to secure practical benefits for women. And that was the decision of L&L. And it was a case where a woman had worked in the home for a long period of time, had made no financial contributions to the property that the family shared together, and her brave lawyers, including the now retired Justice Catherine McGuinness, mounted an argument where they tried to revive some use of this provision in relation to the women in the home, and argued that her work in the home ought in and of itself be deemed to be a contribution to the home that was capable of being recognised by the court in the same way as, for example, paying the mortgage on a monthly basis would have been. The rationale being, by working in the home, she had freed up the husband in that relationship to do that financial work in outside the home. That argument succeeded in the High Court, and Judge Barr found that in applying complex rules of private law that decide how contributions to the purchase of properties turn into property rights, if you like, that the courts, because of Article 41.2, were obliged to take account of a homemaker's work in reaching that calculation. And he in fact awarded her a 50% on equal interest in that family home. Unfortunately, for the future of that provision as a practical tool for women, that decision was overturned in the Supreme Court, the Supreme Court taking the view that this was really for the courts to step into a legislative role inappropriately, rather than to assume the traditional role of the courts of redefining and reframing legal principles. And we've seen debate right up to the O'Mara decision that Claire just mentioned on what in fact Article 41.2 covers. So interesting debate between the Chief Justice and other judges in the O'Mara decision as to whether married women or unmarried women are captured by that protection, whether married mothers or unmarried mothers are captured by that protection. Chief Justice O'Donnell going so far as to suggest that in his view, unmarried mothers were as invisible to the constitutional drafters in 1937 as they were in public life more broadly at that time. So debate ongoing about exactly the scope of Article 41.2's reach, if you like, in relation to both the home and the types of homes captured by Article 41.2, and with that the women captured by those provisions. Interestingly, one other earlier decision raised the possibility that implicitly the work of men in the home might be captured by Article 41.2, an idea that was floated in an earlier decision but not taken up thereafter in subsequent case law. So does home have a place in the Irish constitutional framework at all, if its impact has been, if you like, limited and underdeveloped in the context of Article 41.2? Two other places of note. The only other place where home is specifically mentioned is in Article 42.2 of the Constitution, which guarantees the right to parents to educate their children at home. And that's not been developed at all by the courts. And the closest comparator that we have really is Article 40.5 of the Constitution, which protects everybody's right to the inviolability of their dwelling. That is the place that they live, regardless of whether they own it or not. But what's interesting, I think, for our debate today, when you look at the approach of the courts to that provision, has been that they have interpreted that protection for the home as very much a negative guarantee. That is a protection of a sphere of privacy against state intervention or interference within the home, rather than as any more substantive guarantee, a right to a home or to any positive state support in relation to the acquisition or the maintenance of a place to live. And that bears, I think, quite directly on the debate that we're having at the moment about Article 41.2. And I'll just briefly recap on how we got to the current proposal that you all have before you today. Interestingly, there's a significant degree of citizen input into the overall debate that has led to the referendum that we've had today. So we had two iterations of citizens' assemblies, that is, representative groups of citizens who are brought together to hear from experts and learn about potential constitutional reform and then issue recommendations on that. Two iterations of that fed into the process leading up to the referendum that we'll be having next month. But the wording that we will see, and that you can see before you today, is critiqued for being a somewhat diluted version of what was recommended in those two iterations by citizens, specifically insofar as it doesn't impose any substantive obligation on the state in relation to protecting in a practical way, in the kind of way, for example, that was being argued for in the L&L case, doesn't impose that kind of obligation on the state. The key language, the critical language used in the proposal is that the state shall strive to provide support for care work in the home. And that language, interestingly, is language that we only see otherwise in the Irish Constitution in Article 45. That is the provision that I mentioned to you earlier as being non-justiciable, that is only for consideration in the political sphere rather than in the judicial sphere. So it is significant, I think, that the proposal isn't to put a new provision into that non-justiciable section of the Constitution. That was an idea that was proposed at various junctures leading up to this referendum, because in some interesting decisions in the past, notably in relation to property rights, the courts have said, look, if we had a choice as to whether to put a provision, if you like, in the main body of the Constitution or in this section that is not for the attention of the courts, and we decide to put it in the section that is for the attention of the courts, that suggests the courts can do something with this provision, that this isn't a provision that is out of bounds. So it's interesting in that we have language that is weak and reflective of those directive principles, but an overt decision to choose to put this provision in relation to care in the main body of the Constitution. Significantly, I think it would be put in the main body of the Constitution by a current referendum. That is a current vote of the people. And that would be regarded as giving renewed democratic impetus, if you like, to the idea that the value of care work in the home is respected and is something that the state has to look to. Against that, we do consider this constitutional referendum against the backdrop of a judicial culture in Ireland that has traditionally shown reluctance to give directions to the elected branches of government in respect of how to spend resources. Okay, so in thinking about how a court might interpret the strive to support language, it's important to bear in mind that general judicial concern that in order to show due respect to democratic decision-making, judges ought to defer considerably to the democratic processes decisions in relation to the expenditure of public funds. So it is likely that at the very least, if the proposed amendment is enacted, the state would continue to be given by the courts very considerable leeway in how it would fulfill its obligation to strive to support care within the home. And the duty language and the direction of the injunction to society rather than the state would be new provisions for the courts to deal with thereafter. But it is likely, I think, reflecting Claire's views on durable relationships, that we would be unlikely to expect a dramatic change in approach on these issues from the Irish courts if the amendment is adopted. So thank you very much for your attention, and I look forward to the discussion.
Good evening. Thanks for inviting me to participate. I was the only man on the panel. I feel a little bit nervous. So I just want to begin at the outset by saying I'm not advocating a no vote. I'm not purporting to tell anybody how they should vote. But I am telling you why I am going to vote no on specifically to the care referendum and the wording of 42B. So in order for you to gauge the authority or legitimacy of what I have to say, I need to explain, I'm a senator on the Trinity panel, elected recently. But as an army officer, I did my PhD on the experiences of my female colleagues in Óglaigh in the Irish Armed Forces. Long story short, that PhD uncovered shockingly high levels of abuse, harassment, bullying, sexual assault, up to including rape. Of a sample of 60 of my female colleagues that I interviewed, 59 reported some form of abuse, and as I said, up to and including rape. When my research was published, I experienced what is now known as whistleblower reprisal. I was beaten. I was suffered a sustained campaign of character assassination by the military authorities, by the General Staff, by the Department of Defence. It was alleged that I breached the Official Secrets Act, which is a criminal offence. I thought I'd go to prison. So I'm somebody over the last 20 years as an academic who's published in the area of, both men and women operating in and out of prescribed gender roles in the workplace. So I have an interest in that area. So I hope you bear that in mind when you weigh up what I have to say about the wording of 42B. So, what I would say about feminism is, enjoy it sensibly. It destroyed my military career, blew up all my friendships. Anyway, so look, I'm a parent. I'm a carer. I've 4 kids. My eldest is 23. Living his best life. I've my 22-year-old Owen, who's in neuromuscular disease. He's a student in Dublin Business School. I have a 19-year-old daughter, more of which later. And then my youngest boy is 16, he's in transition. My 22-year-old was diagnosed with a neuromuscular illness, Pelizaeus-Merzbacher disease, in 2002. And that's when I entered the parallel universe in Ireland of being a carer and having a disabled citizen as a member of the family. It is Alice through the looking glass. We live in a parallel universe. And I can't emphasize that to you. Everything is a fight. You're fighting the Department of Social Protection, the Department of Health, the Health Services Executive, the Revenue Commissioners. There is absolute contempt in this state for disabled citizens. I don't know why. It's another debate. I think it's some kind of a weird post-Catholic, post-colonial shame thing. We are outliers in European terms in how we legislate for the rights of disabled citizens. We're the only country in the European Union where disabled citizens and carers have no right to treatments, therapy, support, surgical interventions. That's why you have children awaiting complex spinal surgery. Children becoming permanently paralysed on that waiting list as we speak. Because disabled citizens in Ireland are considered, and disabled children are considered as having less human value than other citizens. And the discrimination and the cruelty that's meted out to disabled citizens and carers would not be tolerated, quite rightly, for any other protected category of citizen. This wording is a missed opportunity, and it is a very, very deliberate wording. You have it there. The government, the Attorney General, Cabinet, they rushed this wording through. Minister Roderick O'Gorman went to the committees and used the government majority to make sure that there was no PLS, no pre-legislative scrutiny of the legislation. I sit on 2 of those committees, and the government representatives came in and voted down any pre-legislative scrutiny. The amendments to the Constitution were rushed and guillotined through both houses, and such is the timeline of the legislation that even if they had accepted an amendment, it couldn't have been incorporated. You have to understand where this government resides ideologically. They are highly resistant to the idea that disabled citizens ought to have any rights. And we are European outliers in that regard. So the wording says that we would strive to support care, and it gives constitutional expression, read it, to the notion that care is primarily or exclusively the responsibility of the family. Both the Citizens' Assembly and the Joint Oireachtas Committee on Gender Equality, headed up by Ivana Bacik, leader of the Labour Party, they both strongly recommended that the wording include a commitment on the part of government to support care in the community. The wording is really simple from the Citizens' Assembly. The state shall take reasonable measures to support care within families, hooray, and the wider community, and shall promote and protect the rights of people with disabilities to live independently and enjoy full inclusion and participation in the community. The government struck that down. The Joint Oireachtas Committee asked that they included support for independent living and care outside of the home. Struck down. So we have this wording, strive to, which, as you quite rightly pointed out, is not justiciable. And that word was very carefully chosen to indemnify the state from any legal obligation to support citizens with additional needs, whether it be disabled citizens, children, adults, or elderly people. World Health Organization, every single one of us will become disabled in our lifetime for an average of 8 years. If you vote for this amendment, sorry, I'm not proposing how people should vote. I couldn't in conscience vote for this. I've struggled. In the last 20 years, I'm a senator. I'm a noisy, provocative person who's well able to advocate. In the last 20 years, I have not received 1 hour of respite from the state in relation to my son's care. Now, when he went from the paediatric to the adult services in 2019, take note, 2019, not 1919 or 1819. I approached the local disability services manager and asked what was the plan for my son for him to transition and live independently. And I said, well, he lives at home with you. That's the plan. And I said, but what happens when I die? And I said, I'll put you on to the social worker. Social worker said, but you're living at home. He's living at home with you. That's the plan. I said, but what happens when I die? And she said to me, does he have siblings? Yes. Does he have a sister? Yes. Well, she'll look after him when you die. And that is the ideological position that's held in conservative Ireland as given expression in this wording in 42B. It does not vindicate the rights of either the family, carers, disabled citizens, the elderly. It is a complete and utter, I have no issue with what we're taking out of the Constitution, the anachronistic references to women in the home and so on and so forth. But we really need to stop and think about what we're going to put into the Constitution. And I think this gives the state and the health services executive an opt-out for providing us with support. And that's been my experience. And, as a senator, Trinity students are my constituency, Trinity graduates, of which 75,000 are registered to vote. I don't know who voted for me, but thank you. Trinity graduates don't write to me. They don't email me. I get emails, hundreds of emails every week from families who are in crisis. Elderly parents in their 70s and 80s to whom adult children in their 50s and 60s are being returned to them for this decongregation. I have families who go into crisis, they're diagnosed with a terminal illness, and the child, an adult child, 20, 30 years old, there is no appropriate accommodation, no supports in the community, and they are inappropriately placed in nursing homes. There are 2,000 adults, younger adults in their 30s and 40s, inappropriately placed in nursing homes in and around the greater Dublin area. It's an archipelago of neglect. And this wording, last year I introduced a disability rights bill into the Seanad, which would for the first time bring Ireland into line with the rest of the European Union, to give disabled citizens the right to treatments, therapies, surgeries, imagine, to give them that right, and also to have respite and care. The Cabinet issued an instruction that it be struck down, and only because of a rebellion on the government side, we managed to get it to the next stage. 2 weeks ago in the Seanad, in a debate on care, a government private member's motion on care, I proposed an amendment that we immediately adopt the UN Convention on the Rights of Persons with Disabilities, including the optional protocol, which would vindicate Article 19, giving people a right to independent living and care supports. And the government voted it down. So all the hand-wringing and all of the, I heard yesterday, unbelievably, that Minister O'Gorman and the Taoiseach, Leo Varadkar, both said in interviews, this is great. Families can now sue the state for the services and supports that they're not getting. This is dystopian. I think this is a retrograde step, the wording. I think it's a missed opportunity. I know a lot of feminists are kind of holding their nose on this and saying, well, it's better than what's there, but it tramples all over a group of citizens in our republic that are egregiously discriminated against at every hand's turn on every basis. So look, I think I've gone past my 10 minutes and I'm happy to answer any questions later on. Thank you very much.